The living will, also called an advance directive for healthcare. Some people think this is the easiest part of the estate planning process, and some people think this is the hardest part of the estate planning process. I'm going to walk you through Alabama's living will so that on signing day you're fully prepared for where you want to mark. Backing up a little bit, what is a living will or an advance directive for healthcare? Well, it's giving an advance directive. It's saying if these things happen down the road, this is what I want to have happen or not have happen. If I meet the triggers that this document outlines, then I want X to happen. I want Y to happen. And the code of Alabama allows you to put different wishes based on different triggers so that your wishes are honored if you can't speak for yourself. So let's run through this form together so that when you're ready to sign it with me or one of our estate planning specialists, you know what you're going to do. All right? And remember, this is about doing what you want to have done if you can't speak for yourself. That's why we sign it now while you're alive and healthy and competent, so that if this day ever comes where you're not competent and very unwell and you're at the end of your road with some of the triggers that we're going to see in just a moment, what you want to have happen happens to you. Okay? So the code is going to ask you a couple of questions for a couple of different categories. Okay? And the first category is terminally ill or injured. Okay? If I become terminally ill or injured, terminally ill or injured is when defined as when my doctor and another doctor decide that I have a condition that cannot be cured and that I will likely die in the near future from this condition. Okay? So we've got, examining this definition, we've got some safeguards here. My doctor and another doctor that cannot be cured, has a condition that cannot be cured, and that's very strong language, cannot be cured, and that I will likely die in the near future from this condition. So that's a significant safeguard as well. It's not that, oh, you're 98 and, things just happen. It's, I will likely die from this condition. It cannot be cured, and my doctor and another doctor make that determination. And you can't speak for yourself, okay? I should have highlighted that above. This is only if you can't communicate with yourself. And I'll point out, I don't love this language that the code uses. It's not just speaking. Communication is not just speaking. It could be eye blinking or gripping hands or something like that. So this is only if you can't communicate for yourself. So we looked at the definition of terminal illness or injury. The code is going to ask you two questions. It's going to say, do you want to have life-sustaining treatment if you're terminally ill or injured? And it's going to say, do you want to have artificially provided food and hydration if you are terminally ill or injured? Okay? As you review the documents, take a moment and review the definition of life-sustaining treatment and artificially provided food and hydration that you will answer the questions for on signing day. Go ahead and pause the video if you need a moment to review and think about what you would put here if you were on signing day with me or one of our estate planning or elder care specialists. When you're ready, resume the video. All right, so continuing on, the next part of this document asks you, look at what it does here. I'm going to go a little bit out of order. It asks you the same two questions. Do you want to have life-sustaining treatment? And do you want food and water provided through a tube or an IV? It asks you the same two questions, but for a different category. Okay? This category is permanent unconsciousness. Okay? Just having all kinds of fun today talking about terminal illness or injury, and then we move on to permanently unconscious. So, this definition, let's look at what this definition is when my doctor, that could be your attending physician at the hospital, could be your primary care physician if you're not in a hospital setting, and another doctor, so we have that language again, agree that within a reasonable degree of medical certainty, I can no longer think, feel anything, knowingly move, or be aware of being alive. Okay? Sort of a harrowing thing to think about, but we want to plan for it. We want what you want to have happen to your life and your body to happen. They believe this condition, that is the doctors, 2 doctors, believe this condition will last indefinitely without hope for improvement. Notice it doesn't say for recovery, it just says for improvement. But you ain't going to improve, is what they're saying with this standard, and have watched me long enough to make that decision. I understand that at least one of these doctors must be qualified to make such a diagnosis. Sometimes I get questions on this. Don't love the language there from the code, but just like everything else in the code, that is the law, set of laws in Alabama, we have to work within the confines of the code. We cannot expand from the code. At least I'm not comfortable doing so without extreme reticence. All that means is at least one of these guys needs to be your attending physician or your primary care physician. And when I say guys, I mean guy or girl. You get the idea. All right, so permanent unconsciousness. Again, we have the 2 doctors as a safeguard here. We have a pretty significant definition of what permanent unconsciousness is. Lasting indefinitely without hope for improvement, not full recovery, just even hope for improvement. And they have watched me long enough to make that decision. So all kinds of safeguards in this definition as well. So on signing day, you'll indicate whether you want life-sustaining treatment if you're permanently unconscious, and same thing for food and water through a tube or an IV. I want to have food and water provided through a tube or an IV if I am permanently unconscious. You'll initial on signing day by either yes or no. Other directions, I typically don't recommend my clients write anything in here other than a very small subset of possibilities. What's an example of those small subset of examples? If you're Catholic, last rites being administered, something like that. Sometimes people want to put burial, cremation wishes in on this. It doesn't inherently hurt to do that, but Alabama has a separate law and a separate way that you have to do that under Alabama law. So putting it in here might just confuse you and lull you into a false sense of security thinking that you did it right. So, if you want burial cremation, that needs to be in a separate instrument under Alabama law, and we can talk about that at your signing appointment and get that done for you. I don't love using this section for the following reasons. The code provides you a form, and the more you deviate from the form, the more kind of risk you're taking. So I don't love filling out that section other than a very small subset of things like last rites if you're Catholic. Having said that, all right, I really like this modification here, okay, because I get a lot of questions about, well, I still want morphine, okay? Let's look at this. If you wish to receive water or fluids for your comfort or to administer medication, place your initials here. Yes, I want water and fluids for my comfort or to administer medication. Where's the no here? Is there a no down here? Nope, I took it out, okay? I'm not letting anybody put no here, all right? I'm not going to risk that. Here's what this says. Even if you put no anywhere up here about I don't want life-sustaining treatment, food and water through a tube or an IV, I don't want that, this says I still want morphine. I still want solutions for the lips to keep lips moist. I still want comfort care. I still want water and fluids to administer medication, okay? So you can still have those things while saying, I don't want my life artificially sustained, if that is your wish, okay? So I like having that in there, and that's very popular with my clients, and I hope you like it as well. I get a lot of questions. Again, this is a form from the Code of Alabama. I'm a certified elder law attorney. Very few of my clients are pregnant. It's in the form. Again, I don't like messing with the form. There's no form trust. There can't be. They're too customizable. But this, the code provides a form. I don't love deviating from it. This is actually true from the Patient Self-Determination Act of the 1990s, I think. If a hospital does not follow your wishes, for whatever reason, they must make some sort of reasonable accommodation, maybe getting another doctor or medical professional, maybe moving you hospitals. That doesn't happen very, very often. All right, the hard part's over at this point, okay? You'll sign, date, give them your birth date, things like that. Two disinterested witnesses is an important part of the process. Be sure and don't have your spouse or children or proxies sign as witnesses. And guys, that's it. It's putting your wishes down in an advance directive form saying, if these days come, if I'm permanently unconscious or terminally ill or injured, I want this to have happened, I want this not to happen, and things like that. So having watched this, I hope that you feel more prepared for signing day, and remember to come to your signing day with me or one of our estate planning specialists with all your questions that we are going to be ready to answer. Thanks for watching.